Oftentimes when clients come to us, their lives have been devastated by a horrific event. We're talking about the husband whose tumor was misdiagnosed, the wife who goes in for routine surgery, suffers a cardiac arrest, and passes away on the operating table. And we're talking about the mom who's struck by a commercial box truck, has her leg shattered and can't walk. These are very difficult cases. They require a high level of focus, precision, and specialization. Because when the stakes are high and 7 figures is involved, you can rest assured that your adversaries are going to be on the top of their game. So you need to be on the top of yours. I started as a prosecutor in the Brooklyn District Attorney's Office in New York City, and I've been practicing in this area for over a decade. And throughout those years, I've been able to identify certain patterns in the way that these cases develop. I call this the art of the case. The first step is learning the case. And especially when it comes to medical malpractice cases, we take pride in understanding and learning the medicine. We have a great appreciation for it, and we take a very academic approach to the way we understand these types of cases. We're not just reading the medical records, we're ordering medical treaties, we're doing the research, we're reviewing peer-reviewed journal articles, and we are trying to get on the forefront of this area of medicine before we proceed with the case. The next step is building the case. We go to great effort to find some of the best experts available in their respective fields of practice. What surgeons are the most well-published? Who's performing these types of surgeries? We work with accident reconstructionists, engineers, economists, life care planners, just to name a few. Also, in the beginning of the case, we're preparing it as if it is going to trial with a mind's eye towards how are we going to be able to demonstrate the evidence to a jury. So very early on, we're getting custom medical illustrations made and animations as trial exhibits. And we think that it's a reflection of your belief in the case and your investment in the case. We're also conducting depositions. And this is going to be a preview to your adversaries of how effective you're potentially going to be at trial, especially when it comes to deposing the target doctor. You see how well you know the medicine. What are your cross-examination skills like? Can you control the witness? Are you going to come off good to jurors? These are all important aspects of building up the case. The next step is making the case. And we're fortunate in the state of New Hampshire to have mandatory mediation. That means before a case goes to trial, both sides are hiring an independent party to oversee settlement discussions. And you could believe that before we go into that mediation, we've done all our recognizance. Who's the insurance adjuster? What motivates them? Is there an excess policy? Is there an opportunity to play the motivations of one insurer against another insurer, or when there's multiple defendants involved? We also find out who's going to be the appropriate mediator for this type of a case, what's their temperament, and so on and so forth. We're putting together comprehensive PowerPoint presentations because you're demonstrating to the adversaries that you have the capacity to execute this case in front of a jury, where you're marshaling in all the evidence and all your exhibits just like you would in a closing argument. The final step is we're closing the case. We spend a lot of time and effort in trying to understand the psychology behind negotiation. We read books on human behavior in order to give us that edge. We've taken classes at Harvard Business School on negotiation because we know if you could effectively negotiate, you're going to see significant swings in case value. We know if an offer is fair and reasonable because before we enter into that mediation, we've already conducted a full-day focus group where we hire people from the community to hear the evidence and deliberate just as if they were real jurors. So we go into the whole process with eyes wide open. We also go into mediations with structured settlement brokers, people that are able to present financial plans for the clients in order to invest the money effectively where it's earning a significant amount of interest in a tax-effective way. Sometimes we've seen net settlement recoveries double, triple, even quadruple in value. Ultimately, the goal is to execute the case in a way where you are getting a substantial settlement offer, and then your client is allowed to make a decision of how much risk they want to take. They have the opportunity to have control over the outcome of the case. And we like to think that we have been able to achieve successful results because, frankly, we practice with integrity. We don't take these cases lightly. And the other side knows that when we're involved in a case, we believe in it with every fiber in our being. And we think that translates with really substantial settlement offers. And if not, we are more than prepared to go to trial.